Wait.
Yes,
Now back to mention item number 34, Madam.
34.
In fact, this was heard on the last occasion and accordingly, Madam, my Larded Friend has filed an additional affidavit. I just got a copy now, Madam. Can it be taken up Wednesday?
Wednesday.
If it is convenient. to do.
This is heard by, it's not a part heard.
Was
Not
part
part.
verdict. We wanted to file a rejoinder to the affidavit reply filed by the
In
petitioner.
fact, I have not seen it there.
Affidavit you have filed.
We have already filed. Copy was also served, but my friend here has not done through it.
No, it's an additional affidavit.
Okay.
So I don't know what it is.
Is spread for by Mr. No, let this matter be listed on 28,
But not 28, Madam. Can it be 29? If it is convenient to load.
29, 10, 20, 25. So as to enable the Mr. D. Panglan counsel for the petitioners to go through the additional
Yes.
which has been filed, which is filed by the, which has been filed by the respondent. Respondent FCI.
Madam, item 32 and 33. Madam, here, Learned AG will be appearing. And I have
Yes.
taken the consent for, from the other party, Madam.
Why this is?
Learned AG will be appearing. So can it be fixed on 17th of November?
Why AG is required here?
Madam, there is an instruction from the department, government. Madam.
On the ground that learned advocate general shall appear in this matters, Mr. N. Ratan Learned Edison Advocate General press for listing of the matter after 2 weeks,
No, on 17th of November.
17, 11, 2025. You are also there.
Yes.
But
Okay.
it's no specific interim order, but then
Mr. K.
it was,
Agarwal, Learned Senior Counsel.
but there was no specific interim order as such. But then I said that, okay, because the
And
hearing was
Mr.
to taken up on
Mr.
day-to-day basis, I said that we will not press the execution.
Be
That
perfect,
is all.
Learned Counsel for the respondents.
My lord.
Learned Senior Counsel for the petitioner and Mr. B. Perfect Learned Appellant, and Mr. B. Perfect Learned Counsel for respondent number
1 to 71.
1 to 71.
1 to 71. Are present.
All right, all right.
Interim order passed earlier.
Please, Lordship. I beg to mention item number 27, Lordship.
Hmm.
According to Office Note 23/10/2025, service reviews evident, Lordship.
Hmm.
Lordship, may
So wait for your turn. We'll see it listed orders.
Lordship.
Yes.
My lord, in item number 9, the leading counsel, Sri Tony Patil, has requested for some accommodation, my lord. He is out of station today.
On the prayer of Mr. Jayasri Learned Counsel appearing on behalf of Mr. T. Patil, Learned Counsel for the petitioner, that this matter listed after 2 weeks.
My lord. Item number 12 as well, my lord.
Same order, 12. 12 and 13 then in the
12, 13, 14 are connected. my lord.
12, 13, 14. Huh?
Great.
Can there be a fixed date, Madam? 12, 13 and 14.
You decide that after 2 weeks. It should be that 2 weeks. Same order, but this, I think 12, 13, 14 listed on
10th.
10, 11.
Problem.
May it please, your lordship. Lordship, I beg to mention one unlisted matter, lordship.
What's the urgency?
Urgency is that lordship already we have filed this petition for quashing and setting aside of summoning order passed by the JMFC, Honorable JMFC Court, your lordship.
Here we set as the summoning order.
Your lordship, already we have approached this honorable court. However, for technical reasons, we were directed for refiling to file with liberty, your lordship. So we are filing today itself. So
Criminal petition.
yes, lordship.
So we'll take it up on Monday.
Lordship, actually, the summoning order is for 29/10/2025 of
Okay.
this month.
Monday is 27. We'll take it
Your
on
Lordship.
Monday.
If it could be possible for today, Your Lordship.
Monday.
Highly obliged.
Please, my lord. My lord, I beg to mention item number 24, my lord. My lord, 24, my lord.
Ah.
My lord, I've been instructed to seek adjournment, my lord, for the respondent number 1, my lord, on behalf of this, okay, my lord. He is indisposed, my lord.
24.
24, my lord.
And for the petitioner.
What is this?
Sir,
24.
So,
CRP, madam.
Huh?
We have challenged an order passed by the civil judge.
When do you want?
Can be on 24th of November, madam.
Can I take up this matter? It's a defamation.
It's a
Defamation
defamation
suit.
case. Defamation suit. It's pending before the civil judge, madam.
Now, can I take up this?
Yes,
matter?
there is no.
Okay, on the prayer of Mr. So-and-so, Learned Counsel, appearing on behalf of Mr. Lee Sophie, Learned Counsel for the respondents,
respondent 1, my lord.
and the prayer not being objected to by Learned
Petition.
Counsel for the petitioner, Mr.
HK now. Hiran-
H.K. Nath, Learned Counsel for the petitioner, that this matter be listed on
24th of November, madam.
24, 11/20.
The prayer for interim may be considered on the next day because there is
We'll see.
an observation in on the last order.
If it's there, it's okay. We're not modifying that.
Madam, obliged.
Deeply obliged.
My lordship, I beg to mention item number 10 and 11
Yes?
on behalf of T. Thakur. Leading counsel is first due to personal he could not
On the ground that Mr. T. Tafag is in this post, come on, Mr. So-and-so, Learned Counsel for the petitioner, submits the letter will be listed after 6 weeks.
lordship and after weeks.
Eh?
After weeks.
Huh?
After weeks.
After?
A week.
After 2 weeks. Where there are list after 2 weeks.
My lordship, another matter mentioned for admission hearing on next Monday, 27.
Why? What is the urgency?
Uh, advocate will coming from Guwahati, so
So we're not, all the time we cannot act on the convenience of the lawyer.
Yes.
When it is supposed to be listed?
yes, just instruct me.
What is the matter? It will come up on its own term. You check it out. If there is urgency, you mention next week.
Item number 1.
I think cannot take up this matter. This is considered the civil, the money suit, transfer of money suit.
Yes.
Consequent to the order of this court.
Yes, madam.
I appeared in that, in the matter. During that thing, huh? When does the meet what? I cannot take up this thing. This before any other appropriate meet, huh?
Item number 2.
Yes. How can we grant you a time to, you seek the appropriate remedy from the appropriate court?
Yes, madam.
You are not denying your, the liability,
Yes, madam.
then basically you are asking for extension of time to pay. No, we cannot, sir, sorry, dismissed. You approach the deputy commissioner. You approach the deputy commissioner. Sir, you approach the deputy commissioner. I will give you liberty. How can we extend the time for execution? No.
With that, whether customary court can have a pecuniary jurisdiction.
No.
The amount.
They have. But basically, you have your basic, essentially you are asking for extension, that you are not,
Yeah, no, they,
disputing the liability.
yeah, they're not
18 lakhs
one,
something.
it is not one time.
Yes, so you approach the executing court. Hopefully it is decided by the customary court. So in that line, they will take the lenient view. We'll give you a liberty. Heard Mr. A.K. Arup Bhattacharya, learned counsel for the petitioner, who submits that he may be allowed to withdraw this petition with the liberty to approach the appropriate executing court or the forum for seeking extension of time to pay the liability as per the decision of the customary court. Mr. Praise allowed. Civil revision petition stands closed on withdrawal with the liberty as spread form.
Item number 3,
You should not call for the
Yes,
case that trial court record.
trial court record,
Has been charged sheeted.
charge sheet. It's in a stage of evidence,
It's a matter of trial.
but my lord, there's
How
no
can we
material to justify section 341. That is wrongful restraint.
It's
But
all
the
right. That's a matter
foundation-
of trial.
But my lord, the foundation upon which
If
the
they
whole,
cannot establish, the prosecution
All-
establish a matter ends there.
all the sections were dropped, my lord, except 341.
That's why.
But my lord, prima facie, if we peruse the record,
It's a matter of trial, sir.
my lord, the foundation is that there was a use of firearm and that has been dropped. And basing on that foundation, the whole case was built. And that sections are dropped. Now, there's no chance of,
The trial court will take care.
But
That is the case.
that would be an abuse of
You
process
will be
of court, my lord.
acquitted.
Since prima facie, I have
You will be acquitted. No, nothing.
until the next date, my lord, till the TCR is being called for, my lord. Maybe kept in evidence. This is a matter of 2014, my lord.
Sir, we cannot quash all the cases.
So this is a matter of 2014, my lord. I have
Doesn't
been
matter.
subjected to harassment since last
It's all
11 years.
procedural hardship or hazards.
I
I
can,
cannot help it out.
I can justify, my lord, there's not even a single ingredients attracting section 341 of IPC, my lord.
So it's a good case for you.
My lord, the reason given by the learned trial court below is that I was present in that district, my lord.
Yes.
Merely being a president,
So that you are not present and it's not required. Mere presence will not establish guilt against you.
my lord, but the reason is as such that if today an offense is committed of wrongful restraint in Naharlagan, for a simple reason that I
You
was
don't
also in
know.
Naharlagan, I would be booked
Sir,
in
you
341.
better to fight it out.
Until the returnable date, my lord, since I am suffering from.
Oh, I am not
14
ready
days.
to issue it, even issue a notice.
My lord, TCR.
Huh?
TCR may be calling.
Mr. Jayasri learned counsel for the petitioner by filing the application under section 4528 BNSS 2023, praying for quashment of the criminal proceedings of GR case number. What is this? GR case number 04 of 2024 under section 341. Now it's 341 only. Charge has been framed under
Yes,
341 of IPC 1860 read with no arms act also.
No, I'm said. Everything has been dropped. That's the reason, my lord.
341 of IPC. Mr. Call for the scanned copy of the trial court record. Mr. D. Tado, learned additional PP. Enters appeal action of the by this. List after 4 weeks.
2 weeks.
Huh?
2 weeks.
3 weeks.
Grateful.
item number 4,
Yeah, Lordship. Lordship, this is a joint petition filed by the petition number 1, 2, and 3.
So it's same, not that this application under so.
My lord, there is a fundamental defect in this petition, my lord.
Huh.
My lord, the one of the victim has not been implicated as a party, and the settlement has been entered by the informant only, not by the victim. And victim has already attained the age of majority, my lord.
Lordship, for that, I have given in my affidavit that petition number 2 is my son, Lordship. The complaint is lodged by the father. And I have given, has been authorized by petitioner number 2. In the affidavit, I've stated. In my averment also, Lordship, I've stated since the.
It's okay, you get the affidavit or get the settlement with the
One of the
victim
victim,
also.
one more victim is there, my lord.
Yes.
An implement petition need to be filed then.
And Lordship, in that.
See, will you are seeking quashment, we'll see.
Yes,
It has to be proper. Victim is the real victim.
The victim lordship, that is my son lordship, and his,
Two victims are there, man.
Is he attend majority?
Yes,
Plus
Lordship,
there is
yes.
the another victim is also
Yes, your lordship. One of the victims is not even implicated.
there. What's there? If you can, as a father, can have a settlement with them. No issue.
yes, lordship, before that.
Withdraw. File fresh, get those things.
Yes,
Ask Mr. B. Jamalan, counsel for the petitioner. No, Mr. B. Jamalan, counsel for the petitioner, fresh for withdrawal of this criminal petition with the liberty to file a fresh appraisal also. And so, huh?
Yes.
So with the liberty as for Mr. Swain, he had the initial petition.
Obliged.
Obliged.
Item number 5.
Yes, without prosecution section.
Yes, but Lordship, this is a PC Act, Lordship.
Yes.
They have their own steering council, Lordship.
So
Maybe,
you are fussing the buck.
Lordship,
You are PP.
yes. But the.
You are overall, whether there is special PP or not, doesn't matter. So,
My lord, stay may be granted, interim may be granted, my lord.
we have not heard you with the question of stay.
My lord, because it's prima facie, my lord, that there's no sanction and 19 languages.
Yes, who is who is special PP?
Lordship.
You are as a PP. If there is a special PP, as a PP, your heads are off.
No, Lordship, but
You are the PP of the state.
yes.
All the special PP should be under you. You don't realize your responsibility and power and responsibility. You are a big man.
But they are particularly open for that purpose. Lordship.
Physics doesn't matter. The power and responsibility entrusted the public duty. All right. Are you PP of the state? No. Yes. Then, not Mr. Learned Counsel for the What do you say? Without provision sanction?
Lordship, maybe.
Sir, on the issue.
Look at the Lordship, even they did not annex the entire circuit council. Lordship.
Suppose if it is not, if no provision section is, obtained, then the court take cognizance or frame charges.
With regard to the IPC section, Lordship. IPC section.
It's all PC Act also. Charges has been framed, right?
Yes, my lord.
I don't know. I'm just asking.
My lord's language of section 19 is very categorical, my lord.
No, I'm asking him. I'm asking PP. Let us learn together. What do you say?
Lordship, with regard to the PC Act Lordship only, Lordship. Otherwise, these IPC.
Why? Why? Why not IPC? Mr. M. Karthik, Learned Counsel for the petitioner. This is an application under section 528 shall be in a so. Praying for enforcement of the criminal proceedings in what is the case number? PC Act case number 08 of 2024. Under section 409, 420, 468 of IPC. Radio section 13 within bracket 2 of PC Act 1988. Call for the scanned copy of the file for record. Deloitte and public proceedings. That is police. It's only, you are only the state of government, it's a public prosecutor only. That's your internal arrangement. If they have a special PP or something, but you have to, you are the commander. You are the chief. You are the boss. Petitioners to take steps for service of notice upon responding to the barrister, so and so, huh? What I said, call for the trial, scan copy trial for records, huh? Pending production of the trial for records, the further proceedings of criminal case, further proceeding of the PCA case number UA 2020, pending before special judge.
Yes, my lord.
PCA, UPA, settlement system.
Your Lordship, name of the special meeting.
He's not there. He's not a party. You arrange it, it's your arrangement.
Item number 6.
Yeah, please. Lordship, herein they are, the state respondents, Lordship, they are not releasing my compensation amount.
Why?
Solely on the basis of a representation filed by the private respondent 4 to 12. 39 is the representation submitted by the private respondents. Now they are contending that the lane is under dispute, Lordship, which is already decided way back in the year 2000.
Not Mr. So and so, learned counsel for the petitioner. Only one. One
Petitioners on the
next para. Claiming, praying for release of the land compensation amounting to rupees 6,94,458.86 in respect of what?
widening
Land.
lane,
For the land acquired for construction of what?
road, Lordship.
What road?
Widening of road, Lordship.
Widening of road at,
Changwanti between kilometer 4,
where do you get it?
page number 23, Lordship.
Notice has been issued or what?
Not
Oh.
yet, Lordship. Not yet.
23. Construction oblique widening or oblique improvement of existing route to NSK GCL in respect of Highliang to Changwanti between kilometer 44.05 to kilometer 50.82. That's all.
Lordship.
And then again, Sangwanti to Walong. No,
Lordship, my is in respect of this 4.5 or 0.
4.5 to 50.
Lordship.
45 to 50.
Lordship.
No, what have I said initially? No, initially, at the beginning, praying, huh? No, claiming for a compensation, huh? Amounting rupees, right, huh? Then you keep it that last part, huh? Rama, this writ petition has been filed on the ground that the respondent authorities have withheld the payment of the compensation on the ground of the complaint of only on the ground of only on the basis of the complaint made by private respondent.
Lordship, 4 to 12.
4 to 12 after the gap of after the gap of
4 years, Lordship.
4 years from the date of the final decision, final award, which has been passed in favor of the petitioner.
Lordship.
Issue notice returnable by 4 months. As Mr. So and so, the next concept. Is who is the one? You are one.
1, 2, 3.
MS Basan, London State Council, and Mr. London DOJ enters the clearance and accept not to be held. Respond number 1, 2,
3.
and
4.
4. Who is private respond number 5? It's 5 to
Oh, sorry, 5 to 12, Lordship.
4, huh? No formal notice is shown. However, except for this. Petitioners to take steps for solution notice upon responding members. 5 to 12.
5 to 12.
5 to 12. Sorry, step for so extension. Huh? Pendency shall not be a bar to release the amount claimed by the petitioner if provided the petitioner is actually entitled to. You release it, what's there?
Obliged.
Item number 7.
My Lord, 7 pertains to occupation of land without due procedure of law, my Lord. Since
This
September,
notice.
at this stage notice only, my Lord. Since September 2009, my Lord, the land is occupied. They are still processing in, my Lord. 16 years have gone by.
Heard Mr. B. Papalan counsel for the petitioners.
Petitioners, 2 petitioners.
Petitioners. By filing this petition, the petitioners have prayed for a direction to the respondent authorities to make payment of the land illegally occupied. Land of the private land of the petitioner illegally occupied. Land of the petitioners, measuring 9.184 acres at Segong Des Pramantri. Illegal occupied by the respondents. What respond?
Number 1 to 4, man.
1 to 4 is the occupant.
Respondent number 4.
1, 2, 3, and 4.
Respondent number 1, 2, 3, and 4. List of the petitioners also appears for payment of rental compensation for first occupation as the respondents have been occupying the land since 2000,
September 2009.
September 2009. Issue notice return for 4 weeks since Mr. M. Kato, Learned Council for Learned DJ and Mr. M.S. Arbasan, Learned State Council. There's appearance on behalf of respondent number
567.
all the respondents, both of you.
Yes.
Well, all the respondents, no formal notice. The extra copies, so it's, this after 4.
Obliged.
Item number 8.
Your Lordship,
Yes.
my case is regarding there's a violation of
Termination.
my Lord, termination and
Well, issue notice, what can we do?
my Lord,
Where is the appeal order? Where is
if you
it?
order is page number this 19, my Lord.
19.
My Lord, may I read, my Lord? 19.
Yes.
Whereas Ms. Pagjum Yora, daughter of this, had been erroneously appointed as ALC against the presumed vacant post of Sri Sonam Danduk Lama. And whereas Sri Sonam Danduk Lama has not resigned, is still serving as ALC in this establishment, thereby nullifying the said vacancy. Therefore, in the interest of public service, the erroneous appointment of Ms. Pagjum Yora to ALC stands revoked and her appointment stands cancelled. She is relieved from duty as ALC with this. Your Lordship, the issue is in fact not about vacancy, my Lord. There has been some foul play there.
How you are appointed?
My Lord,
How you are appointed?
I was appointed, my Lord, as ALC begins this contingency.
How?
my Lord.
How? What is the process?
My Lord, in contingency, we applied, my Lord.
Hmm.
We applied. It is in page number, my Lord.
So if somebody applies, you just appoint them.
Almost 14 people are appointed, my Lord.
No, maybe 100. But I'm just asking, how is the appointment procedure?
Procedure generally in Arunachal Pradesh shows such contingency, my lord. Contingencies are appointed, my lord, on this the fitness basis, my lord.
In Arunachal Pradesh?
Yes, my lord.
In not other parts of the country?
My lord.
Not other parts of the country.
In fact, it should not be in law, my lord.
Then
There should be, but the problem here is actually I was appointed and accordingly made to this join there. And
release your notice, nothing.
my lord,
Your basis of appointment is not legal.
my lord,
You have not validly appointed. Whether there's a vacancy, no vacancy. You have just approached. On your approach only that you have been appointed.
your lordship, at least in our humble opinion, my lord, at least opportunity of being heard should have been given.
No, that's what I'm asking.
My lord.
First question, how you are appointed?
Right.
Then we'll proceed further.
My lord,
That's why I only issue only notice. Can't help it out.
my lord, at least opportunity of being heard should have been given.
No, when your appointment itself is not on the basis as per the rules, as per the law, it's nullity. It's honest. I don't know.
Apart from that, my lord, we have submitted.
We had it
also,
We're also having a little knowledge what's happening in the Arunachal Pradesh.
my lord. We agree on that.
So it should not be allowed. That is against the rule of the law.
My lord. Yes, we understand that, my lord. We understand our position, my lord. But
Rule of law.
at least what we assume here is at least some sort of opportunity to express our should have been.
No,
Right,
when
my
your appointment itself is not valid, is not in accordance with law. That is your right. It is honest. Anyway, we'll issue notice.
My lord, at least some interim protection may be given, my lord. At least we have some.
Why you have to plead? Why do you have to avoid that on your application you were appointed on a vacant post? You are not supposed to say that. Maybe you are very transparent, very candid, right?
My lord.
You yourself has shown that your appointment is not in accordance with law.
My lord, of course, we cannot show this any.
Very fair, very fair.
And there was no advertisement.
I understand you are very fair. But that fairness will not help you getting the job.
My lord,
We appreciate your fairness,
some protection may be given.
but the law doesn't support you to give you any appointment.
At least, my lord, some protection may be given until this returnable death.
What protection?
My lord, we have in fact given our this representation, submitted our representation also. But
We'll see that pendency shall not be barred to consider your representation. Yes, madam.
Notice at this.
Why you are appointing like this? Suppose if there's a vacant post, you would not have nominated her, even if the appointment is not in accordance with the public employment, constitutional scheme of public employment. Just because that she has been appointed wrongly on a post which is being held by some other person. We are not thinking about how the appointment has to be channelized or rationalized in accordance with law. Is not it? Had Mr. T. Tagum, learned counsel, learned counsel for the petition. Challenge made in this writ petition is to the order dated 3009/2025, passed by Deputy Commissioner, Siang District, whereby the petitioner the appointment of the petitioner as ALC has been revoked. We are cancelling the appointment on the ground that the appointment of the petitioner was erroneous, as the post on which the petitioner was appointed is being still occupied by one Sri Sonam Denduk Lama, who is still serving as ALC in the establishment. Issue notice returning in by 4 weeks. Private respondent is there, no?
Yes.
One private respondent.
Good. Lama.
For 1 and 2.
Lama.
My-
Unnecessary why you are dragging him. It's not his fault.
No, my lord, actually, in fact, he is also involved there, my lord. Actually, he was not appointed there. He was not serving there,
So
but
we'll
just
see.
to out me.
Let's see how
But-
they have, all of them have been.
Yeah, I know, I understand, my lord. In
As
right
Mr.
time,
As MSG at the London edition, senior government enters appear in the respond number 1 to 4, 1 and 2, no formal notice in the House extra. Then petitioners to take steps for service of notice. Respond number 4, 2, 3. 3. Where is the consequences? It is provided, next paragraph, it is provided pendency of the recruit shall not be about to consider the representation of the petitioner.
always
Matter number 15.
Just to complete this matter, yesterday, my lord, we took almost 2 hours.
Then why this is listed here?
My lord,
for
Keep it-
final disposal, my lord.
Why you could have kept it for a part hard.
Lordship was of the view that this cannot be my lord, kept as a part heard. So therefore, my lord, matter has been fixed today, as Lordship has leave today for some other work, administrative work. my lord. The urgency has been shown by them. Because of that reason, my lord, matter has been listed. today,
Tuesday, they'll be court.
my lord. In fact, it was almost further, but
Yes,
Same
madam,
as-
madam will be sitting on Tuesday.
but Lordship has already expressed that our critical thing, my lord.
Then why you have not,
My lord, that is the whole reason, my lord, the urgency shown by the other respondents. The matter has been fixed today, my lord.
anyway. This to be heard,
Yes,
Yes, my lord.
we are ready, my lord.
is the urgency.
Urgency, my lord, interim order is operating exercise. The interim order was passed by your lordship, my lord. My lord, the entire tender process has been suspended, my lord.
What is it about? Construction of?
Construction of road, my lord. Now your lordship know this is the peak.
Construction of road.
Yes, my lord. Now this is the peak, my lord. season, my lord.
Considering, my lord,
What is your ground?
my ground is, my lord, I have been prevented from participating in the tender process, my lord, leaving, my lord, the authority, the tendering authority, he himself remain absent from the office during this entire tender period. my lord. The time limitation has been given, and during that period, my lord,
That
He-
has been negatived. Your papers were not in accordance with the tender, the terms of the tender.
Correct.
Therefore, your documents were rejected.
but my lord, that is the crucial and the crux of the case, my lord. The intricacies of the case is, my lord, technical bid has to be done on so and so. date.
That's the reason I think they took so many, you have
But, my lord, as per the NIT date,
see, this
Every-
court believe in, hearing on the point.
my lord, to my understanding, issue is very simple, my lord.
I'll give you 15 minutes.
My lord.
You
Within 15 minutes, my lord, I'll not go into the entire
Ah,
documents, my lord.
Ah.
Only documents, my lord, which is very relevant is, my lord, as per the NIT, the time that bidding time has been given, my lord. And even technical bid has, when it has to be held, it is also given, my lord.
Hmm.
But my lord, irony is, before technical bid, my bid has already been rejected. That is the whole, my lord, case.
yes, then we'll hear.
My lord, NIT, if Lordship can use the NIT, my lord. It is in page number, my lord, 34.
Yes. Page 34.
Yes, my lord. Just, I'd like to read the, my lord, the contention of this.
Not, don't read, just once.
My lord, it is double beat system, my lord.
Ha.
And my lord, terms and condition, my lord, serial number 1. It has been given, my lord, the period of availability of online bid and data.
This is upgradation of Yamcha ADC
Correct, ma'am.
headquarters to Nirmaba ASC headquarters
ma'am.
road. Under Switch. Ha.
Yes.
Yes. That-
Serial number 1, my lord, when
Ah,
that has,
the-
my lord,
the
the
online date and date, online date and date. Yes.
and date of opening, Lordship has seen at the last portion,
Hmm.
that 15 July 2025, my lord.
Yes.
And that period is, my lord, they have given, my lord, in the above column, my lord, from 30th June to 2025, my lord, to 14 June, my lord. This is the, my lord, the bidding period. my lord. Now, what other terms and conditions, my lord? I'll take your lordship's the serial number 5. It is relevant and important, my lord.
This bids can, the bids can be deposited before the term prescribed paying the cost of sales. Ha.
Correct. Documents and the non-refundable in case of arrest, so and so, with EMD, madam. It is important, madam. With EMD and other original documents to the Executive Engineer Yamsa Division PWD from 30th June 2002, 5th July 2025, madam. And during office hour at the specified opening place for the work in the list, listed in the tender, madam. Madam, whereas the bidding period has been fixed from 30th June to 14 July 2025, but by this condition, my lord, the hardship has been put so as to eliminate, so as to, my lord, award the work to the student candidate, madam. Student,
So according to it's the period, the time given is
too short, my
too
lord.
short.
Whereas, my lord, bidding period is they have prescribed
Yes.
till 14, my lord.
Yes.
And now, still then, my lord, we tried our best to participate. And
7 days time. This 7 days.
No, my lord, 5 days only, my lord.
5 days. Okay. But this is can be deposited before the by paying the cost of bidding documents
Along with,
in cash rupees so and so along with DMD and other original documents to the agreement. The from 30 to the leaving office or this to yes.
my
Then
lord, lordship knows, for preparation of such documents in the tender process, my lord, it took time, my lord. The original document has to be submitted on or before 5th of July
have
2000.
you submitted within this period?
Yes.
Then
We went to the office of the deputy executive engineer to submit entire documents in original, my lord. But as I have pointed, my lord, the executive engineer, he himself remained absent from the office during.
it's all right. It doesn't matter.
Yes,
Whether he's absent or whether you have submitted within this period.
yes, madam.
Then
Then that has not been taken into
they have
consideration.
not received,
Not received, madam.
they have not accepted.
Not accepted,
It's
not
your
processed,
allegation.
not processed.
So you submitted the bid on all this EMD and other things
Yes, madam.
from 30 to when did you submit?
On 3rd and 4th and 5th, we went to the office of the madam.
Third,
3rd July 2025. 4th
Third.
July
fourth,
2025
fifth.
and 5th also, madam.
You tried to submit,
Yes, madam.
it was not accepted.
Not accepted, madam. And madam, that will be, madam, clarified by the, madam, the statement of the, madam, the two officers whom the work was.
Just wait. So according to this, on these 3 days, you tried to submit,
Madam,
but it was not accepted
not accepted.
due to absence of the executive.
Executive engineer, madam. Now, madam, directly straight away, madam, may I take your lordship's.
So you are not, in that case, essentially you are not questioning the shortage of time.
Of course, madam, we are raising that issue
See,
also.
number one, you are saying that the 5 days
Yes.
time is too short,
Yes, madam.
but then you have tried on
Right,
these
our
3
best.
days,
Submit the document.
within this
Yes, madam.
5 days,
Yes, madam.
period 3, 4, 5.
Yes, madam.
But then, in view of absence of
Yes, my lord.
the executive engineer,
Correct.
your documents or bits were not accepted.
My lord.
So which one you would like to?
My lord,
I
the
mean,
first one is still we tried to,
would like to, pressed
my lord,
into,
my lord, not accepted at all, my lord.
not accepted. Shortage is out.
Shortage is
Shortage is out.
almost out, my lord, but as per
So will not take care, consider the
my lord,
shortage.
that is also relevant as because the superintending engineer issued encouraging them later by extending the time for submission of the documents, my lord.
Yes.
That
Anyway,
is also relevant.
anyway, yes, next.
Next, my lord, I will take your lordships to the Annexure 8, page number 68, my lord.
Hmm.
2 officers were engaged for receiving of such documents, my lord.
70,
Page 68, my lord.
68.
Annexure 8. Madam. This is handwritten copy, madam. And type copy is page number
This
6.
was under duress. You have forced them to write this.
Madam, when the officer is not available and the junior engineers were assigned for the receiving of the work,
What does it matter?
madam,
It's a-
one has to at
it's
least
just-
make
it's
such
just
statement.
Receipt of the bits.
Madam, duresses cannot be,
They are the
madam,
part
taken.
of the officer. The proceedings.
Yes, madam.
Junior engineer assistant, they can receive what's wrong. These are all trivial issues,
Madam, that's because they by madam,
non-essential
madam,
or unessential.
it is a material, madam. It's directly,
It's okay. You are trying to say that to show this say, page 68,
madam.
type copy is page 69,
Yes, madam.
that it is evidence from the statement that
Executive
the
engineer.
the junior engineer executive is not
Correct.
absence. Therefore, you could not submit.
Correct, madam.
Your the bids have not been accepted.
Correct, madam.
Yes. Then
Now respondent number, madam, page number 72,
yes.
73 is the type copy, madam. The superintending engineer issued this corrigendum
Hmm.
extending the last date of submission of the bid, madam.
Okay. So did you submit?
No,
Try to
madam,
Submit.
Still they did not accept, madam. This
Wait.
has not been taken into consideration, madam.
Where
Even if in
How-
their affidavit also it is clearly stated this has not been taken into consideration.
from where we get that you have tried to submit?
Madam, till such time, madam, he remain absent, madam.
That's what I'm saying.
Yes.
What doesn't matter?
For which, madam, without
If the office is open and the officers is there other than the executive engineer, it can be always accepted. Even the clerk can accept it.
madam, it is one thing in submission of such standard documents. The NIT, madam, earnest money deposit has to be produced in the original manner. That has to be submitted. One, first, and other original documents has to be shown.
They say that they have entrusted these officers.
No, madam, that has not been, madam. I'll come to, madam, that particular, madam, the issue directly to the affidavit filed by the respondent number 4, madam. It was extended till, madam, 10th of July, madam. That has not been taken into consideration.
Yes.
Madam, without, madam, having no alternative option, we, madam, file FIR before the madam concerned policy station, madam. And that has been taken into cognizance and issue notice to the executive engineer also, madam, on 7 July 2025. And in this is official documents, the official record issued by the, madam, the officer concerned. Page number 76, madam, FIR. Notice, sorry. This is official documents, madam. The officers in charge, madam, issued notice to the, madam,
See, in your page 74, second para, fourth line. However, we are informed that in the absence of executive engineer. No, before that, during this period, our tender application and relevant documents were in fact received and acknowledged by the subordinate officers of the executive engineers office, who issued us a receiving acknowledgement. It was accepted, received.
Hello.
However, we were informed that in the absence of no further proceeding or formal entry of our documents could be carried as they were specifically directed not to proceed further without this instruction. Now, there's no dispute that your documents were received, acknowledgement were issued to you. Now, issue
That-
is it could not, according to you, it was not
Process.
processed. Because without
Correct.
the,
It was
as
not
per the instruction of the executive engineer,
correct, madam.
right?
This has to be verified by the
Ah.
executive engineer first, then it will be processed, madam.
So, because of this, your tender was rejected. Your bids were rejected.
Rejected on, madam, therefore, madam, I'll take your lordships to the affidavit in opposition filed by the respondent number 4.
No, I'm just asking whether it was rejected on that ground. Because it was not accepted, processed. Therefore, you were not allowed to participate.
No, madam, ground of rejection is again different, madam.
What is the ground of rejection?
Ground of rejection is, I have not complied with it, the conditions, terms and condition is specified in serial number, clause number 26 of the standard bidding documents, madam.
Then matter ends there. That is different issue.
No, madam,
You have to challenge that.
madam, whereas when I have not participated at all,
No.
how my,
The
my,
question of participant, just see, your, and when I took up this matter, when we passed the stay, when we passed the interim order,
Madam.
because time was short, too short. Number two, you were, because of the absence of the executive engineer, you could not submit. Your bids were not received.
Correct. That was the
Right. Therefore, we privacy found that you have been deprived to participate.
correct, madam.
Now, by your own showing, your bids were accepted, but it was not processed.
Yes, madam.
By now, they filed an affidavit saying that your ground of rejection of your bid is in a different ground,
Another question
as
is,
per clause 26 or something like that.
madam, another question is, madam, another question is, when the technical bid has been already fixed by the, madam, the inviting of notice inviting tender, madam, prior to that, how might the documents can be rejected, madam? That is, madam, the terms and condition.
No, see, that's what I'm saying.
Scrutiny will be-
That's why you have to challenge that. That was not your
Madam,
case.
scrutiny will be done only on the
That was
specified
not-
date.
Your case is not that. Suppose you have been rejected on certain ground. You have not challenged that.
Madam, may I kindly appreciate one.
Your ground is that time was number one, too short. Number two, your bids were not accepted
Madam,
because of the absence of the executive engineer. So you could not, you have been different from participation. This is only a simple ground you have
Madam,
projected.
madam, when,
All right.
Madam-
Now, by filing the affidavit, they are saying that apart from, that's why I said non-essential, whether these or that. But they are saying that your bids were accepted, received, and they were rejected. Not only you, another bidder. Out of 4 bidders, 2, including you, 2 bidders were rejected on certain grounds,
yes, madam.
which you have not put to challenge now.
That is only in the affidavit form.
That's
Now they are
absolutely-
disclosing
that means, I would not say, you have concealed the facts, you have suppressed the facts.
Madam, in that, madam, we
You
have,
know that this thing, the bids have been rejected on certain grounds, you have not printed that. You have not made any aberration, so you have suppressed the material
no,
fact.
madam, in affidavit, in the reply to the affidavit in opposition filed by the respondent number 4 and 5, 6, we have already replied, madam.
Who is
That
4, 5, and 6? Executive engineer.
executive engineer
Yes, then
in person and so, madam.
what is your reply?
Madam, my contention is, when, madam,
Now, admittedly, your rejection of the bids is on some other grounds, as per clauses of the tender documents
Madam,
or the SB.
and that is before the, madam, the technical bid, madam.
Obviously, that can be.
Madam,
See, that is if it is rejected on certain terms of the tender.
Madam.
Whether it is after or, it has to be appropriate at the appropriate stage.
madam, appropriate is,
When your
there is
technical
no,
bids cannot
there
be
is, madam, there is
accepted.
silence
on-
about the terms and conditions.
Yeah,
When-
that we'll see. But problem is you have not challenged all these grounds of rejection. Your projection in the requisition something else, which has been clearly rebutted and privacy, I think it's kind of.
Madam, all my contention in this repetition is, we have been prevented from submitting the entire original documents. How, madam, my documents can be rejected before the, my lord, the date of the scrutiny, my lord.
No. See, you have submitted the entire documents.
Correct, my lord.
That was accepted. No, not the entire. You have submitted certain, you have submitted certain documents, which initially you have said it was not accepted because executive engineer was not present. But then it is shown that by your own showing it was accepted, acknowledgement was issued,
Right.
right? And then ultimately it was rejected for non-furnishing of required documents or original documents as per the clause 26 of the tender documents, terms of the tender.
My lord, there is no specific terms and conditions that is done prior to the original, my lord, in the correct date.
26, man, it's very clear.
My lord, therefore, my lord, may I take your lordship to the that documents, my lord? Annexure
Which one?
of affidavit filed by the respondent number 4, my lord.
Hmm.
What's the knowledge?
So once what? No, it may be little too technical. But then once the point which you have not raised or pleaded, how can we determine? This is not your case. You cannot challenge the rejection, which is not the issue or pleaded in the writ petition.
My lord, this
And there's no bar to challenge that.
too, my lord,
You
but
can challenge that.
my lord,
And perhaps you have not.
I consider that part, my lord. However, my lord, the another, my lord, broader aspect is when I have not at all submitted my documents, my lord.
You have said you have went to the one there,
My
and
lord,
this page 68 also says that
my
it
lord,
was-
that
it was-
is the only
they
photocopy, my
have
lord.
accepted.
That is the only photocopy, my lord. Original document has to be, my lord, without, my lord. I'm asking myself,
Why you have went to submit a photocopy? When
With
the
original
when
documents,
the
madam.
requirements is
my,
submission of originals on
Madam.
a certain days. I mean specified days or appointed days.
my lord, for just a moment, my lord, may I take your lordships to my EMD, my lord. This has to be submitted, as lordship has seen in the terms and conditions, serial number 5. Original documents has to be produced, my lord. That original documents has not at all produced and at all not received, and it was not processed, my lord. It was processed only the photocopy of my tender document, not the original, my lord. And subsequently, my lord,
Let us see the rejection.
rejection, my lord. It is in page number, my lord. Affidavit filed by the respondent number 4.
Page
118.
118, my lord. Office of the, my lord, executive engineer.
Your colleague,
Correct, my lord.
representative.
With, yes, my lord.
Non-fulfillment section 3, condition of contract
Yes.
under additional specific in the your participate in the bidding process for the work operation, you say, and this beginning by the time of submission, collection of the process. It was observed that the requisition stipulated on section 3 condition of contract in the additional income and not present. Bidding, bidder will delegate, fulfill the condition of approved uploading to the details non-responsive. This is on 3/7.
37, my lord.
On same.
Not even before expiry of the date fixed by them.
Huh?
It is on 5th July, my lord.
Huh?
Even if it is considered, my lord, last date of submission is the 5th July, my lord. 5th July. But if extended, my lord, it is 10th July. But my lord, the closing date of the bid is 14th July 2020.
Did you try to submit again?
Admittedly, no, my lord, after this.
Huh?
This has been, my lord, the lately they,
When did you receive this?
my lord, our contention is we have not yet received this, my lord, documents, my lord. Now, my lord,
It's a disputed fact again.
we have not received this document. my lord. Now they are saying that,
See,
that
the point is leading towards the separation of facts, sir.
my lord, we,
Simply saying that you have not received will do.
my lord, by affidavit, we are stating that, no, we have not received any this document, my lord. This has not been at all communicated to us now. Letter may be issued, my lord, Therefore, my lord, this letter would be my lord, the
Then,
best, my lord, this is manufactured
Then-
documents.
then let us see
Comes-
section 3.
Section 3, my lord, more particularly, page number 108,
108.
serial number 6, my lord, 26, my lord.
108.
These are the basic requirement, my lord, 108, my lord, basic requirement, which has to be complied first. Then it will
Where
be
it
processed.
Where it is?
Page number 108, serial number, clause number 26, my lord.
Processing fees shall be collected, division of employment from the engineer and duly completion the examination being done because somebody rejected.
Yes, madam.
This was not submitted.
Where it is?
Same line, not below.
Okay. There'll be somebody here. This is what? This is part of what?
Part of bidding documents.
Okay.
We are not disputing this part, madam.
Then
But, madam,
can
went,
be summarily rejected.
that-
Your case has been summarily
Madam,
rejected.
we went to the office of the executive engineer to submit these original documents, madam, not at all they receive, madam, ready to receive, madam,
When?
on third and on fourth, madam.
On third, you have already said acknowledgement is given, right? In your page 68 something.
Madam, that has not been proceeded.
It has not been processed according to you. According to you.
Had it been the case.
But that was accepted, it was received, right?
Correct.
Received, then acknowledgement was given to you, right?
True, madam.
And finding that you have not submitted the original documents, it was summarily rejected.
And,
Hmm.
and another fact is,
Yes, it was extended up to 10.
yes,
You
madam.
could have done.
No, madam, that has not been, madam, considered as I pointed out, madam. In my pleading also,
Huh?
madam.
110. 120.
No, madam, this is directly rejection, madam, not the, madam,
Yes,
correction and
Yes,
modification.
118.
180, same, madam.
Hmm.
Directly rejected, madam, not giving an
Ah.
opportunity for correction, madam.
Hmm. 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 Hmm.
This is rejection, madam. Madam, direct rejection, madam, as per the CPWD manual, madam, opportunity has to be given at least to make correction if there is any deficiency in the documents, madam. That opportunity is also,
Where is the requirement in the SBD?
madam.
Where is the requirement in the SBD?
SBD, madam, is specifically that
It is
clauses
not
are
done
not
that.
required to be mentioned in the, it will be governed by the, madam, the CPWD manual, madam.
So I've given you 30 minutes. You may challenge this rejection, summary rejection.
Now, madam, another
But
condition is,
it may be too late in the day.
madam, another condition is, madam, since date of scrutiny and technical bid is, madam, fixed, summary rejection can be done before the, madam, the technical bid.
Obviously, why not?
This is
Madam,
section 26.
26 is, madam,
Be summary rejected.
Rejected.
If you don't,
madam, it has to be rejected,
if you
madam.
don't file submit the original documents which is required under the 26.
26.
Can be, in the-
Summary
under
rejected.
26 itself, it can be summary. What is it mean by summary rejected?
It has to be submitted, the rejection has to be, that's
See,
been at least,
clearly, you are not challenging this clause 26.
no,
Let them be summarily reject means what? Before the things
technically,
go into the technical financial.
Financial, all.
if documents produced by the respondent, only that was not known to them after my rejection, man. Rejection was done on 3rd July 2025. And the scrutiny, the Lordship has seen that board was constituted later, everything.
Where's your the affidavit in reply saying that you have not received this? The rejection.
Reply, my lord, they have not said anything about that, my lord.
No, just wanted to, because I don't want to go into the issue of or principle of separation of material facts. If I go, it may have some bearing.
Our prayer is, let us give the fair opportunity to everyone,
No, it cannot be.
so that internet tenderer can
I
also
think-
participate fairly.
We are not commenting on whether there was an absence of the executive engineer or not, how they deal with the thing, but we'll go by the papers and the documents here
When such tender is,
and the terms of the tender.
without giving an opportunity to the internet tender,
You have been communicated,
communication is
so as the in reply that you have not received. We may think about it.
my lord.
By the private respondent, because there is a allegation is there, madam.
The more bigger the volume of the petition, it scared the judges.
No, they have filed, but they have mixed this 68. They have filed, but.
I'm sorry, I'll check out from the record, I'll just inform the court.
No, it's your reply only.
Right.
I don't want to take a view on the, delve on the separation of material facts.
Okay. In fact,
Otherwise, it will cause a damage.
Thank-
Para 16. Okay.
Only document.
Para 16 of reply. Okay. Para 16.
Lordship is asking for that, whether the original document was accepted.
No. Not original documents. The communication,
Communication.
rejection, page 118 here. You just read the para 16. Para 16, you just read. Para 16.
Madam, I'm reading, madam. With regards to the statement made in the paragraph 19, 20, 22, 21, 23, and 24, madam. Thank you.
Anyway, I'll go through it.
Yeah, no.
Heard, mister. That's all.
So therefore, madam, my
Very simple.
humble submission is giving an opportunity to the all internet terror, madam.
Let
What
me
fair-
see. I'm not keeping it CAB. I'll pass the order. You'll get it in there. I mean, I don't know, today or tomorrow, but maybe,
My lord,
or
Hello.
by Monday.
my lord.
madam. And another
I'll
aspect,
pass the order in the chamber. I'm not keeping it CAB.
My lord.
Pass the order. If possible today, it's not, maybe on Monday.
Then also, my your lordship may kindly see, my lord, the going before your lordship, my lord, the maintainability. The Badri Rai has been represented by somebody else only by giving authorized letter, my lord.
Then
It is also not, my lord.
It will be very short order.
Then,
Any
That was not
judgment would
complied
like, any judgment would like to relay?
yes, my lord, I have given, my lord, the list of book, my lord.
Only one.
Uh,
Latest,
I have given
latest and most closest which you would relay. Not all.
lodges, my lord, that will be, my lord, GLT, my lord, non-compliance of terms and condition, my lord.
Let us not,
The division bench, my lord.
let us not burden with all this. And the issues are not complicated.
Section 3, then same, my lord.
Ah.
Then your lordship may realize that GLT, my lord, division bench, my lord. This is non-compliance of the terms and condition.
Yes. Only one judgment.
My
You, any judgment?
My lord, it is already settled matter, fair opportunity, my lord, the giving opportunity when the,
If you are relying on
my lord, I'll provide.
privacy, the ample opportunity has been provided to you.
My lord.
You could not furnish the required documents as per the clause 26. Therefore, your your things were, your papers, your bids, attempted bids were rejected,
somebody rejected, my lord.
summarily rejected. Ah.
And
I don't know why
and another
say
aspect,
that you
my lord,
cannot challenge this thing. You may challenge the rejection.
my lord, that also,
Because your projection has been something different, completely different. That's why I'm saying again and again, I'm indicating a suppression of material.
On the first day, my impression of brought such a way, my lord, he has been deprived, he has been pushed out, not to some independent. So that was the impression created, my lord. But
Anyway,
my lord,
you may think over it.
my lord, in that case, my lord, yes, my lord, I'll take instruction from the council.
Or you may withdraw the writ petition and challenge the rejection order.
That is my lord,
That
proposal.
is the shortest way
Yes, my lord.
without burdening me and burdening yourself.
My lord,
Once we pass the order, I mean, then you have to challenge or to accept it.
my lord.
It may have the doors may be closed even before the appellate court. You are passing the order. I'm just giving you a hint.
My
I
lord,
mean, indicating you.
in the meantime,
It's up to you.
yes.
And if you want to say something, you just inform them. You want to take instruction or what?
No.
Withdrawal or what?
No, my lord, since we have already made submission before.
Then in
your lordship,
I'll pass the order. All right.
Item number 16.
May I please, Your Lordship?
Yes.
Your Lordship, this is a bail application.
Yes.
Your Lordship, the accused person was arrested on 05/01/2025.
Yes.
After the arrest of the accused person, he was not served the ground of arrest. He was not communicated the ground of arrest to the accused person. Thereafter, he was forwarded to the remanding court, that is Judicial Measure First Class Inkyong.
Yeah.
And after going through the records of the investigating officer, the very remanding court has remanded the accused person without communicating the ground of arrest to the accused person. From that day, when the accused person was remanded by the remanding court, since from that day, the fundamental rights of the accused has been violated. Until today, the same thing was still not communicated to the accused person. At the time of arrest of the accused person, Your Lordship, though the notice under section 47 of the B and SSS was served, in the said notice, except the case number and the sections which has been charged against the accused person, nothing was reflected. No ground was communicated. And even in the remand order, that is page number 42, annexure 5, except there is a one line in the third paragraph that he has further stated that his family members are aware about his arrest. I'm not talking about the section 48 of the BNSA. That is what is actually communicated to the family members of the accused person. At the time of remand of the accused person, Your Worship, he has not even given an opportunity to challenge the remand order. No any remand advocate, no any legal counsel was appointed for him to challenge the remand order. And only in the same remand order, that is section page number 42, third paragraph from the last, upon perusal of the ground of arrest enumerated the following report, I found the arrest and detention is justified. That is the only one line has been reflected in the remand order. And what is forwarding report? In the forwarding report, except the reason of arrest has been only mentioned. There was no any such ground of arrest was communicated to the accused person. And in my earlier, I have filed an application before the special court, Pasigat. In my debt rejection order, the ground of arrest which was communicated was clearly reflected.
That is only your ground.
That is the only ground.
Bihan
Kumar.
Bihan Kumar's case.
Yes, recently also, there is one judgment has been come this 14 October 2025 by the Honorable Supreme Court. In the case also, it was clearly stated by the Supreme Court that the ground of arrest has to be communicated to the
Yes,
accused
that
person.
has been explained by the special judge clearly.
The special judge has misunderstood, Your Worship. In my that is in bail rejection order, page number 26, Your Worship.
Your Worship, this matter
Your
was
Worship.
taken up by Justice Budi Hapung Unlap.
So
So same judge may be.
it has been disposed of.
No, not
Has it been disposed of?
continuing. On from that application.
Yes, what is the PP? What is the system?
I'm on behalf
Just wait. It has not been disposed of by. I can take up this. Where's the bar? See, if the matter is disposed of, again, if it is filed or the other similar, other bail application filed on a similar, with regard to same FIR, then only it has to go to the particular bench. Not otherwise. Otherwise, you won't be able to take up.
I was a bit confused, that's why.
So you make yourself clear.
Yes. So here.
Yes.
May I, Your Worship? Yes. Your Worship, you want to kindly come to the page number 31 of the bail rejection order which has been passed by the special court Pasigat.
I have seen it.
Yes, Your Worship.
So
In that, it was only the reason of arrest was communicated, which was very much clarified in the case of
where it is page 26.
page number.
Where is where it was communicated? Where it is?
Communication was in the page number 37. That is the notice was first served by the investigating officer to the accused person.
47.
41, Your Honor, page number.
Page 41.
Page 41, Annexure 4.
By whom?
This is by the investigating officer to the accused person. This first communication was made regarding the ground of arrest.
Then
But here, there was nothing like that. The ground of arrest was communicated to the accused person. Your Worship. Going
this is
through-
the only one.
This is the only one, and thereafter, by the remanding court. By the remanding court, there is the next page. There is 42, Annexure 5. In that, from the last third paragraph, upon perusal of the ground of arrest enumerated in the forwarding report, I found that the arrest and detention is justified. That forwarding in the forwarding report itself, except the ground of arrest, the reason of arrest was communicated actually, Your Worship, which is very much available before this order before the report. Which is very much available before this order before the PRC report. That forwarding was made on 06/01/2025 by the investigating officer. Based upon this forwarding report, Your Worship, the ground of arrest was misunderstood by the learned judiciary as a first-class Lincoln. Actually, the ground of arrest was not communicated to the accused person. Even he was not even given the chance to challenge the report.
Yes. Mr. Tado.
Yes, of course, there is no mention in the arrest memo
Ah.
regarding arrest of the ground of arrest.
Hmm.
But in CD as well as other communication letter notice, there was clearly inform him about the arrest, and he also did not report it.
Where it is?
This is in the other CD.
Order sheet, how can you pass an order and keep it within yourself? You have to communicate.
Oh yes, it is from record from this year also.
Yes, Mr. Similar method was taken up the
This has been clarified, my lord. It's no longer, your lordship, this ground communication of no ground of arrest is, yes, I have the judgment, my lord. Darshan, yeah, this Vihan and your Purkasya case has been clarified here, my lord.
I think this court has also passed.
Yes, your lordship.
have- In Darshan's case, Vihan has been clarified. Para?
Yeah, my lord, it start from 20.1.
20.1.
Yes, my lord. It's just academic discussion, my lord, now. Because your lordship, it cannot render the arrest illegal, my lord. My lord will find in paragraph 19, my lord.
Charge sheet has been filed.
Charge sheet has-
Trial is on.
Trial is on. Case is the pending at instance of CC about that consideration charge.
How many witnesses?
There are 5 witnesses.
Will be completed.
Yes.
Last submission, lords.
Huh?
My submission, last submission.
What submission? Yes.
Dear lordship, in the case of Wilson, it was clearly said by the Honorable Supreme Court that at least substantial compliance has to be there.
Yes.
But in the case, what is the substantial compliance has been understood by the investigating officer. That is what required to know your option. That was clearly reflected in the earlier page relation order by the special judge in the page number 32, where it is clearly reflected. May I read your option?
Yes.
It is reflected the second paragraph that in the case diary, the ground of arrest are shown as protection of victim and nature of offense being scenic. The accused is non-naturally, therefore he was not arrested. He would have escaped further the arrest was
Page
page number 32, your lordship.
32.
Second paragraph.
Yes, in case diary, in the case diary.
In the case that your lordship. When it was arrested, he would be escaped. Further, the arrest was necessary to prevent the accused from causing the evidence to disappear or tampering with evidence, and finally to ensure the safety of the accused as the local population was angry and itself was threatened. Arrest memo dated 05/01/2025 to reveal the aforesaid ground of arrest. In the arrest memo, which has been misunderstood,
Countersigned of the witness Sri Shijo NJ and Sri Rajiv Bachcher who are associated with this group.
yes, bro.
Yes.
Your lordship, which is actually shown as the ground of arrest in the arrest memo, and which is reflected in the case diary as a ground of arrest. That was actually not the ground of arrest, as per the Pabit Pukasta case, which has been very much
It's
clear.
a POXO.
This is a POXO. This is a POXO.
Thank you. That's all.
No, your lordship, my last submission order. After this court may pass any. The thing is that what exactly communicated to the
So
accused.
according to you, these the grounds of arrest has not been properly communicated, which
Yes.
is the requirement under the law. Is not it?
Yes, your lordship.
The mentioning of the ground of arrest in the arrest memo will not suffice. It's not a substantial compliance. It's not a compliance at all.
Yes, your lordship.
That is what you are saying.
That is what this one said. And the what has been what has been communicated to the accused.
You are relying on the Bihan Kumar.
Behind Kumar judgments also, even our own High Court also passed several orders. Provide the ordinary judgment to the
Not
honorable.
all judgment is not. You give me one judgment which is most relevant and nearest and the latest.
Behind Kumar, only I think this.
Bihan Kumar will then have been subsequently explained in Darshan's case. Bihan Kumar, you are relying.
Behind Kumar is there and others, judgment of this honorable Supreme Court. So, honorable by the court.
It's okay. Bihan Kumar is the main judgment.
Main
You
judge,
relying on Bihan Kumar.
behind Kumar. Yes.
You consider. Not Mr. So-and-so, then counsel for the petition. Yes, anything you want to say?
Victim and accused are the teacher and students.
Huh?
They are accused is the teacher of the victim,
Yeah.
school teacher.
Okay.
And he committed such serious act in his school premise room. So there is every chance of
You have the case ready. File
teacher-
for records.
teacher
It's here. Huh? Take.
prosecutrix has not yet been examined by the
Huh?
prosecutrix has not yet been examined.
Yeah.
Only 164 was recorded.
Yeah.
So there is every chance of tampering, and mother of victim is a single mother, single parent. So there is every chance of pretending.
Matrix has not been
Mm.
examined.
Yes,
It's a relevant point.
and moreover, accused is from outside the state.
Yes. You are for victim.
Yes.
Informant. Yes. What do you want to say?
My lordship,
Colleague. Yes, colleague. You say the student.
I think it's from the same institution where he has the influence even.
Colleagues or a student?
No, victim is a tribal person.
He is a student.
She is a victim is a student.
Student.
Accused is a teacher.
Ah. So he's not a colleague.
There is no relationship, personal.
influence in this. So,
Student and a teacher.
so,
Yes.
so he has an influence in that institution. So there's a high probability of the influencing the means. And moreover, like after the BP tax, SVP has said, since it's a the informant is a single mother without her husband, so there's no any support. And more, that's why your lordship is then.
Pastor. Heard Mr.
CN Pangyok Lodge.
C.N.
Pangyok.
Panyok, learned counsel for the applicant. And also had Mr. G. Tado, learned distant PP. For the state and Mr. M. Ube, learned counsel for this. Respond number 2. 2 and 3. This is an application showing, sir. Pass the order and see the judge. Yes.
Item number 17.
Better maybe pass up.
Huh?
The main council is coming.
Coming from where?
Guwahati.
On the way,
Yes, Your Honor.
on the flight.
No. Through vehicle.
Huh?
Through vehicle.
Okay, so we'll wait for him.
Just possible.
Item number 18.
This 17 is the same,
Yes, my lord.
which
Yes, my lord.
this court has already rejected.
Already rejected the co-accused, same
All
co-accused.
rejected. We just hear them
Okay.
for same thing. They're equally
equally, no, your lordship,
It's not, I think.
same incriminating material, madam. Nothing
Same material.
new. Only ground is that ground of arrest, which has already been decided by this court.
Hmm.
Nothing new, new ground, your lord. Item number 17, madam.
17. They will take up the same.
Yes, sir. Item 18.
Nothing. Same order we have already. Yes, 18.
At 18, PCR was called for, madam. But I have not received yet.
This is a bail.
Yes, madam.
Let's do.
NDPS, madam. PCR, trial court record.
Heard Mr. So-and-so learn counsel for the petitioner. Mr. T at. No, and Mr. T at the London Institute for this thing. TCR as called for is yet to be received. Registry to send the matter. This after 2 weeks.
1 week.
From where?
Session court.
UPR.
Yeah, after where we, after we.
Oh.
We'll fix that at Bellman, we'll fix that at third. We'll fix it on third.
Okay. Third.
Better.
Yes. Deeply over.
Obliged.
Item number 19 and 20.
What to do, sir?
Lord, I can hear my lord, but my lord is not visible to me. I hope I am audible.
Yes.
Very well.
Now
Now my lord is
I have raised myself to get yourself visible.
my lord, they have filed 2 interlocutory applications.
Yeah, that's the problem. I said, Kapil, Mr. Kapil, I said, let us proceed. Since you have filed all these things, what can we do? We'll have to give them an opportunity. For today, it's good, but then. So what do you want?
So, my lord, so far as my lord,
To file an objection or whatever.
my lord, we will be filing objection. My lord, I pray for 2 weeks' time because election petitioner has gone to Delhi for his surgery. So 2 weeks' time I require. My lord, we commencing from 10th of November.
And then both the IA.
Both the IA, because my lord, in other IA, that is IA 261, I have a problem so far as Schedule B documents are concerned. Because Schedule B documents are covered by Rule 93, Sub-Rule 1. And my lord, before filing evidence on affidavit of the witnesses, they want those documents to be summoned before the registry. So there would be certain difficulties. My lord, I would put those things in writing. Schedule A documents, I have no problem. Schedule C documents, I have no problem.
Filing it.
Filing today.
Are filing.
In the course of the day, you will get the copies.
Let's see the order. What was the order? Last order. Today is fixed for filing of the
Evidence. And my lord, the 4 witnesses, I understand, they may file evidence in affidavit of 4 witnesses. Total, they have got 33 witnesses.
for filing of the, okay. You're filing today. Then we'll we'll have to again grant them time to.
Once you file it, it will be for cross-examination also, another instance. And the IAS DPP for the objection, they have to file objection.
No, first we'll have to clear that IA and all, then only we'll proceed. Is not it? Is not it, sir? What do you say?
So, my lord, IA may not agree for 2 weeks.
No,
time.
once IA, unless we clear up the IAs, we'll not be able to proceed with. Is not it? Even the affidavit is filed today. Yes.
My lord, evidence on affidavit, they can always file. Total, they have
Yes.
got 33 witnesses. And I have been given to understand that today they are filing evidence on affidavit of 4 witnesses. If I am right. This is what I have been given to understand. Subject to
9 witnesses. 9. They are saying 9.
9.
He's saying 9.
Okay, if it is 9, my lord, then even then, they have given total 33 witnesses. Some of them may be government officials, so their evidence on affidavit will not come. But even then, there would be certain other private witnesses. So that part they can continue. I have no difficulty with that. But so far as IAs are concerned, my lord, I will be filing my objection. So for that, I pray for 2 weeks' time. Meanwhile,
we'll
they may
say-
continue.
In IA, huh? In IA, huh? First, I heard Mr. DJ Kapil, learned counsel for the applicant election petitioner. In IA 260, huh? By filing this application under order so and so, 7. Applicant or election petitioner prays for leave to produce additional documents in the matter. Mr. P.K. Learned Senior Counsel assisted by R.L. Tungan, Mr. Learned Counsel to the opposite party respondent. Praise for and is granted, we'll say, just say, praise for and is granted 2 weeks time to file objections. List after 2 weeks, we'll just say. Then we fix lots. Then in IA 2261, same order, but then this is an application under what?
Order 16 rules.
Order 64 for
Issuing someone to produce documents.
issuing someone to produce certain documents. Huh? Here also,
Yes, my
you
lord.
are filing
Yes, my lord. Schedule B documents, we have objection.
in
Not
main
schedule B and
petition.
schedule C.
Mr. D. Kapil, heard Mr. D. Kapil, Learned Counsel for the petition, election petition, and Mr. P.K. Learned Senior Counsel assisted by so and so. Huh? Mr. D. Kapil, Learned Counsel submitted. You would be filing the affidavit in. Evidence is the affidavit of 9 witnesses during the course of the day. List the matter as agreed. List the matter on when.
Lord,
We'll give a fixed date.
we commencing from 10th of November.
Fixed it when to answer. November.
10th November, we commencing from.
What about 14 November? Friday.
I have, all right, perfect. I have no
14,
difficulty.
14.
14.
14, huh? Yes.
Item number 17.
Yes.
My lord, this is an application under section 483 of the BNSS for the tail of 2 weeks,
Same grant,
same ground.
which we have already disposed of.
Yes.
There's no change
No,
except the name of the,
name of the
accused.
accused persons. Now, here in this case, my lord,
Same order you approach. higher
one thing
office.
I would like to draw attention before this, my lord court, that our division bench, Guwahati High Court division bench recently observed that the Bihan Kumar judgment will be prevail regarding the non-compliance of section 47 and 48 of the BNSS. And the recent view taken by the apex court in this regard, Darshan judgment, that was ruled out by this our division bench. my lord.
How can you get it?
That would be-
Division bench has ruled out
Yes.
the judgment of the Supreme
When two
Court.
similar views are possible for the same matter, one is Darshan and one is Bihan Kumar. Then Bihan Kumar prevail.
But when you distinguish, with the question of ruling out, ruling, this is what national investigation is. Para? Paragraph?
Paragraph 15, my lord. Para number 15 and 16.
What is it?
Two other citations, my lord.
Why?
My lord, one apex court has hold in a one citation, which has been Director of Enforcement versus Subhash Sharma. That was dated 21 January 2025 in para number 8. In para number 8,
What?
once a court while dealing with a bail application finds that the fundamental rights of the accused under Article 21 and 22
Certain position.
Constitution of India have been violated while arresting the accused or after arresting him, it is the duty of the court dealing with this bail application to release the accused on bail. The reason is that the arrest in such cases stands vitiated. It is the duty of every court to uphold the fundamental rights granted under Article 21 and 22 of the Constitution of India. That has been observed by the apex court. And taking into consideration all these aspects, similar bench of our Guwahati High Court has granted bail to 3 accused persons in a serious nature of offences like POCSO recently, which I have given, my lord.
I cannot have a different view.
Yes.
Just that I have already passed it. You may be correct. I don't know once I have passed it, but I cannot recall that order. Even if
For
I
the-
that you may have genuine.
For the other accused persons,
Then other is same.
my lord has
All everything same. Except the name of the accused is the different. Similar order.
And-
you approach the.
And my lord, so far as this,
High Court.
the decision relied by the honorable.
Get it, let this order set aside. Taking in all this judgment.
And
Your bench, Supreme Court.
my lord, one and only my prayer before this honorable court. Justice must prevail, my lord. This is a constitutional bench, my lord. And
Sir, I have already passed the same order in a similar method. There is no change except there is no differentiation. There is no difference except the name of the.
on that occasion, my lord has observed the cases of Darshan Kumar. That was. But after that,
I cannot recall it.
after that,
Can I recall it? Can I review my own order?
my lord,
Well,
I am
sitting
saying
in the
this because
Jurisdiction.
after Darshan judgment, my lord, our division bench order has been passed. On that regard.
You go to division bench in that case.
And my lord, before division bench, the judgment has not been placed. If two Supreme Court decisions are inconsistent, High Court can't follow one overlooking the other, must try to be reconciled them
That's what I'm
both.
saying. Yeah, I'm sitting, this court is sitting criminal jurisdiction now,
Yes.
bail matters. So if you are agreeing, if it is against the judgment of the division bench and against the Supreme Court, what? High Court.
Obligement.
Get it set aside. Same order,
Obligement.
Of like,
same order. This was this. Can't help it out.
Matter number 21,
Just write record your name. Mister? Yes, Mister? MK Singh? MK Singh and PP, additional T additional PP and H. Jaram, Learned Legal Aid Council for the respond number 2. 3, 2 and 3. 2 and 3. Went. Yes. Yes.
May I start?
Yes.
Yes. As for the order, which is part earlier, that if any affidavit is to be issued or filed, it should be filed on 22 October and 24 October is fixed for the hearing of the case. Now, here in the case, though there are 22 accused, and out of that, around 10 accused persons have filed their affidavits and objections. But, well, I have seen the entirety of the affidavit, nowhere they deny, rather they admit. Now, this is a very interesting case that while the notice was issued, it was issued for cancellation of the bail. Now, but when the court has taken cognizance suo motu under section 428 of the BNS, in that case, it is for quashing and setting aside of the wrong or bail orders. Now, the quashing and setting aside of the bail for wrong orders in bail has different footing from the cancellation of bail granted for misuse of the liberty. So here in the case, that the cases fall under POCSO Act. When the cases fall under POCSO Act, for POCSO Act, there is a rule, there is a act, and they have clearly given the provisions laid in the rule that how to do, what not to do in a bail matter. And in support after of that, in our own Guwahati High Court has issued a notification. In that notification, it has very much clarified that while taking up any bail matter in a POCSO case, what should be done, what should not be done. Here in the case, that in the notification, it is said that support person should be issued notice. And victim, parent, or victim should be issued notice. That support person is defined in Rule 2 of Rule 2F of Protection of Child from Sexual Offences Act 2012. That is in the rule. And Rule 4. There is, in this case, there is a clear-cut violation of section rules 2 of F, rule 2 of F, and rule 4 procedure regarding care and protection of child. Rule 4 subsection 3 or sub 3 of F. Inform the child and child parent or guardian or other person in whom the child has trust and confidence as to the rights of the child to legal advice and counsel and the right to be represented by a lawyer in accordance with section 40 of the Act. But here in the order, when the order was passed, they have neither issued a notice to the support person, nor they have issued notice to the victim, nor they have appointed.
Yes, listed for what? What is to be done today?
Now, my submission here.
Yes, what is to be done today?
The entirety of the bail, which was granted in PS case number 20 of 2024, 25, is to be set aside in court, and a direction will be passed that all the accused are to be surrendered before the trial court.
Sir, that will require, I think, considerable, consideration. We'll have to hear the matter. We'll have to hear the matter. I've not heard you. You might have submitted something, but I was looking in the brief. Yes. We'll fix it for hearing. All right. We'll fix it for hearing.
Then let us fix on Monday, coming Monday.
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 Malad, on the issue is whether follow by granting day or not, Malad, the details is better.
You decide, and let it be after 1 week, somewhere in next week.
Specific date because we're
Yes,
engaged in
yes,
so much.
you agree to that. Heard Mr. Empertin. You'll be, yes, you'll be leading it. Huh?
In the Eastern Council for High Court.
You and they will lead the motion, right? Heard Mr. Empertin, and the senior counsel, assisted by everywhere for the London State Council for the Guwahati High Court, and Mr. the Pangin London Amicus, and Mr. Swens, and also her for the state theater additional papers and rest. You give your name and for the respondent number, huh?
And for the number 1.
M. Kato, and just give your name and respondent name. As agreed to by the London Council to the parties that this matter will be listed on 1st November, somewhere in November.
Lordship, I'm connecting, I'm connected in this case through VC. I am from Guwahati. Lordship, if subject to your Lordship's convenience, can the matter be fixed in the 2nd week of November, either on 12th or 14th of November, Lordship?
12th of November.
12th of November.
For hearing, huh? For hearing.
Lordship. Extremely obliged.
You just give the Ganguly. You are for respondent number?
I'm for respondent number 4, 5, 6, 22 and 23.
A Ganguly.
A
Yes. Yes. Next.
Good to see that.
Item number 22.
So, please, my lord, I appear for the petitioner.
Yes, what is to be done today?
Counter was to be
Listed
filed.
Listed for what? For filing of counter?
Yes, my lord. I am told early morning they served it on my advocate in Arunachal.
Yes.
They may file it
My
in
lord.
and give me a copy.
My
I
lord,
received information
please.
this morning.
Yes.
I'm appearing on behalf of Mr. L. Kordu, Special PPSIT, as he is unable to appear before this honorable court today due to some personal difficulties.
Yes.
Your Honor, I have filed affidavit in opposition today on behalf of respondent number 4.
So have you served the copy to the Learned Counsel for the petitioner?
Yes, my lord.
Yes, my lord. We've got a copy just now.
So all you have also filed?
No,
Yes.
our affidavit may not be required.
Okay, then Mr. Singh?
No, he was.
Okay. So we'll fix it for admission hearing some other day. Right,
Yes,
sir?
the notice has been issued. Kindly keep
Yes,
it in.
that's
I'll file a rejoinder in 2 weeks. And
Okay.
if it pleases your
Okay.
lordship, kindly keep it in the first week of November.
Ah.
If it is suitable.
Heard Mr.
The one thing, madam, notice in respect of Delhi policies. No, madam.
Huh?
Notice in respect of respondent number 1, madam. Delhi police, madam. I put the respondent number 1 on. Respondent number 1 and 2 and 3, madam.
Doesn't say anything on this. Who is respondent number 4?
Respondent number 4 is the madam.
SIT.
SIT. Delhi police, any notice has been, any steps has been taken for service of notice on Delhi police?
Yes, sir, we have filed. Yes, my lord, we have filed. We have served all the parties. And we filed. And I'm told we have filed the affidavit of service as well. With the date.
Who is the affidavit?
I think the date is 25 September, my lord.
Just wait. For service of notice. Oh. Yes, it's been served by Dusty. We'll just record this, huh? Or Mr. C. Gonsalves, then senior counsel assisted by, who is assisting you, sir?
Miss Sunny, my lord.
Huh?
Miss Sunny.
Who is this?
Sunny Time.
Sunny Time. Then it's counsel for the application, petitioner. Next para, an affidavit has been filed. Affidavit for proof of justice service upon the respondent number 1 has been filed, which is taken on record. Next para. The next para, huh? The respondent number 2 and respondent number 1 according is the service on the notice on respondent respondent 1 is duly been served accordingly. The the service of respondent number notice upon respondent number 1 is complete. Next para. Mr.
Appearing on behalf of Al Kurdu, special PPSID.
Learned, appearing on by Mr. El Kurdulan, counsel with the respondent number 4
Yes, Your Honor.
has submitted that he has filed an affidavit
Yes.
today,
Yes, my lord, today.
and the copy of the said affidavit will be served upon the learned counsel for the petitioner, right?
Yes.
I've received it, yes, my lord.
Mr. Gonsalves, learned senior counsel, phrase foreign is granted 2 weeks time to file the reply affidavit, right, sir?
Yes, my lord.
Mr.
May I
M.
request,
Kato,
my lord,
learned-
first week of November, if possible.
Mr. M. Kato, learned DAJ is present. Who submits that he would not be filing any affidavit. Then you choose the date.
Can any on the 4th or 5th of November, my lord, if it's possible?
5th. As agreed to by learned counsel for the parties, let this matter be listed on 5th November, 5th, 11th, 2025. Yes,
Grateful, my lord.
5th is holiday. I
4th
think
is
so.
possible, my lord.
And 4th,
Holiday.
sir, it is holiday here.
Yes, my lord.
Or 6th,
7th, my
6th.
lord.
7th, yeah. 7th, okay.
Grateful.
Obvious.
Matter number 23.
Yes. Event service reports. List after 3 weeks.
Matter number 25. Service report with respect to respondent 27.
And Mr. D. Panglan, Council for the Community, and Mr. D. Lloyd, Leonard PP, for the state. Award service report, list after 3 weeks.
There's an interval.
Interim order pass and let's continue.
Item number 26.
Lordship, we
Your
didn't receive
Lordship.
CD, Lordship.
Hmm.
She did not receive.
Chief case diary was called for and steps for respondent number 2 was taken, my lord.
Corresponding number.
You are appearing. Okay. And Mr. So-and-so, learned counsel for the petitioner. Mr.
Yes, Your Honor.
S. Learned counsel enters appearance on behalf of respondent number 2. Yes. Mr. Deloy Leonard additional press for 2 weeks time to obtain the
CD was called for, my lord.
yes, that
So as on today, my lord, may I
this
prefer,
after 3 weeks, 2 weeks.
lordship, may I prefer staying the investigation because
We'll see after we'll listing after
because
2 weeks.
CD was called for, that is not placed today, my lord.
Okay.
And
Therefore, they are not, were not able to say that. We'll take it up.
a
We'll
date may be,
consider on that day.
date may be fixed, my lord.
After 2 weeks.
A date may be fixed, my lord. Possibly
After 2 weeks, yes, I mean, you just decided
12, my lord, 12.
12 November. Yes, next.
Item number 27.
May I please? The service report is awarded, Lord.
Not Mr. So-and-so, learned counsel for the service report in respect of 5, 7 to 11 and 15 to 20 are still awaiting. This after 4 weeks. Mr. MS So-and-so, have you filed the affidavit?
No, Lordship.
MS So-and-so, Basalan State Council is present. You filed?
Yes, Your Lordship will file.
Item number 28.
Tender matter, there is a stay order. If
Yes,
item
not yet.
28 and 29, this can be disposed of, my lord.
Not at least in other states. The affidavit in reply.
So we have,
My lord, I think it is not necessary, my lord.
So list for admission hearing next week.
my lord, can it be on Monday then?
Huh?
Because
You agree? You're for private respondent. Yes.
for admission,
What is the issue?
well, it's very short, my lord.
Tender matter, my lord.
Tell him.
My lord, the issue is that, my lord, whether the petitioner is challenging the tender which has been accepted,
Assam
number six,
registration
my lord.
contractor, whether they can participate.
No, no, my lord. Whether the tender who has not been enlisted under the Arunachal Contractors Enlistment Rules, whether it is eligible for
Participate.
participation or not, that is the issue.
Monday. Monday or Tuesday? Monday. Pleadings are complete. Mr. Opa, the land counsel for the petition. In both the cases.
Both the cases. It's
And
related to
Mr.
Manrega.
And Ratan London additional advocate general for state and MS. The and then counsel for the private respondent. In both the cases, respondent number 6. Pleadings are completed. List for admission hearing.
Admission.
Admission hearing on 27.
My lord, endeavors maybe.
It's okay.
Still to be,
Stay order, it's a
That may be-
Manrega work.
And you were considering that the matter pertains to tender process,
Relating to Manrega.
endeavors shall be made to dispose of the matters.
still in stay order.
Huh?
Stay order.
Stay order is there.
In my lord.
Interim order passed and
That's
till then.
obliged.
Item number 30.
She will
Maybe-
receive the instruction, but
Huh?
this instruction is incomplete, Your Lordship.
Further, but you are for?
Petitioner, Your Honor, my lord.
Your name is not there.
In Wakalatam, it's mentioned M. Bagra, Morik Bagra.
Why they have missed your name here?
I don't know, my lord.
I heard Mr. M. Bagra, learned counsel for the petitioner. Next para on the prayer of Mr. P. Sangeeta, MSP Sangeeta, London State Council for the 3 weeks time in granted.
My lord, regarding to
2
this
weeks.
matter, I just humble petition honorable court. This matter directly indirectly connected to the compensation order which passed by the deputy commissioner on 8/7/2025, which is still agreed by the petitioner without any issues and side of the part of the role.
Yeah.
So maybe allow to state this impugn order till the
I
further
don't know.
steps.
I've not seen it. What?
You
You
know,
filed an application for interim order.
already in the petition I mentioned here in the interim.
Why it was not considered at that point of time? When the matter was, when the issue was, I think
Your Lordship, according to last order, Your Lordship, the
Yes.
petitioners were directed to implement the.
issue
private party
notice also on the interim prayer, return in the 2 weeks.
Yes. The part of the respondent only, not in our part, my lord.
Private parties were ought to have made participation.
No.
If
What is
it
your instruction?
Instructions.
You know, in the interim order, for interim order also, it was, interim prayer also, it was, notice was issued.
Yes.
Then we'll take it up next week.
If possible, my lord,
Is grant,
Is
no,
order
in
made.
that case, P. Sangeeta is granted a week's time to obtain instruction. But at least after a week, next week.
interim maybe, my lord.
No, that will consider, that's why we're fixing after a week. We'll consider your interim.
Because my lord, nowadays there is some dispute arises that particular.
Sir, that's why I'm saying,
Yes.
then she has not obtained any instruction. So we're granting him a week's time so that your interim prayer can be considered on the next day, after a week, next week.
If specific date, my lord,
Why?
because it takes more than 1 month. 2 months is already going on. But there are no instruction not in made any specific. And we suffer, Lord.
Give a
Because
fixed date, yes. 30, 30.
Much obliged, 30 October.
Matter number 31.
For hearing. Yes,
Lordship, I'm putting respondent number 2, 3, and 5.
so
In this matter, we don't have any objection, Lordship.
who is for the petition appellant?
Ken Patil.
Non appears for the appellant on call, Mr. Yes,
Yes, ma'am. For item number 21. there has
31.
been 21.
we're taking up 31.
Oh.
Yes, non appears for the petitioner appellant on call. Mr. So and so next para. Learned counsel appears for
Respondent number 2, 3, and
learned counsel for respondent number 2,
3 and 5.
3 and 5 is present. List the matter after 3 weeks.
Your Honor, for item number 21, which is fixed for hearing on 12th November, there is some problem for which I have to change the date on 20. I have asked the permission from amicus curiae.
Item
LSP
12.
PP 21
Anyway, yes, then
fixed for on 20 or 21.
2011.
Yes,
Ah.
20. Much obliged.